Hola, bonjour, ciao, and konnichiwa. Hello, welcome to my presentation for Topics in Professional Writing, ENL 650, Social Media, and the Bill of Rights. I figured we were on a global social media platform like YouTube, so we would be multilingual and we'd say hello in as many languages as possible. Social media and the Bill of Rights. Now, what exactly are we talking about when we're discussing the Bill of Rights? The first 10 amendments to the Constitution are considered the Bill of Rights. They were inspired by Jefferson and drafted by James Madison way back in 1791. The U.S. Constitution has 27 amendments, but the Bill of Rights are the first 10. We're looking at 3 amendments that pertain and apply specifically to social media. I've picked out 3 amendments. One is the protections of the First Amendment, guarantees of the Fourth Amendment, and the applications of the Fifth Amendment, basically because there are modifications in the parameters of these amendments, specifically because of social media. First one that we're looking at is the First Amendment. What is there to say about the First Amendment? Certainly the best known, and one that would be near and dear to our hearts as technical writers, as professional writers in communications at UMass Dartmouth. The First Amendment. I'm going to read it to you verbatim, as it's some of the most dramatic and potent technical writing ever composed. But you should understand every part of the First Amendment. It's very packed with a lot of information, very concise but very packed, and I want you to understand every part of it, such that Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble, and to petition the government for a redress of grievances. Now, is there a limit on free speech? In the vernacular, common parlance, everyday speech, it has been said that your right to free speech stops at the end of my nose. Supreme Court Justice Oliver Wendell Holmes says, you can't yell fire in a crowded theater. Speech or actions made for the principal purposes of creating panic push the limits on free speech or the First Amendment. It was a very well-known Supreme Court Justice case, Schenck versus United States in 1919. It was regarding a defendant's opposition to the draft. Apparently, he was circulating a flyer resisting the draft, and what was said on the flyer apparently was so alarming and so upsetting, it was considered to be inciting panic. And because he was inciting panic in the Schenck case, this was the limit that was set on free speech. And it was the really famous decision. It's Oliver Wendell Holmes when he said, you cannot yell fire in a crowded theater. Now, this case was partially overturned by Brandenburg v. Ohio in 1969, which limited the scope of banned speech to that which would be directed to and likely to incite imminent lawless action, such as starting a riot. And Brandenburg clarified what constituted clear and present danger, the standard established by Schenck, speech that is dangerous and false, as opposed to dangerous and true. I told a judge once you can yell fire in a crowded theater if there is a fire, and actually, that's the truth. Now, this flies in the face of everything that the students at UMass stand for: tolerance, diversity, understanding, compassion. It flies in the face of everything we stand for. But hate speech is protected by the First Amendment. It's protected free speech. So is profanity, and so is misinformation. The ACLU continually has protected free speech and has argued this before the Supreme Court, and the Supreme Court has protected a very, very wide, very, very extensive parameter on free speech. I can give you an example with the misinformation up on Twitter over the past roughly 3 weeks. Somebody who is a very famous person for twittering, there's been misinformation. This election claim has been disputed. This claim against fraud has been disputed. Somebody's allowed to tweet, but the misinformation somebody has been writing underneath it, this is disputed. So this is something that It falls within the parameter of free speech. Obscenity, misinformation, and hate speech. It's criminalized only when it incites a specific threat of violence against a person or a group of people. And it does fly in the face of everything we believe in, but I want you to think about this. If somebody can tell you who you can hate and who you can't, you risk somebody coming along trying to tell you who you can love and who you can't. So I want you to think about that. One caveat. Okay, so what we're looking at are the parameters on social media. Does this wide parameter apply? And we've got an opinion of really a couple of lawyers here on social media. And what are they thinking, and what is the legal thought behind it? And the legal thought behind it is that publishing online is instantaneous. You quickly press a button, and next thing you know, it's published. So the mechanisms that are designed to regulate speech are cumbersome and slow and can't keep pace with the instantaneous technology that we have with social platforms, which or what we have with publishing quickly on the internet. And secondly, there is no editorial oversight that can and has been a restraint with hate speech. These are two attorneys that I researched, O'Regan and Thiel, and how they feel about, or what their thoughts are on hate speech and how it can be regulated in regard to free speech, in regard to social media. So the decision is, where is the parameter on hate speech, on free speech, and social media? And the decision is the First Amendment protects individuals from government censorship, but social media platforms are private companies, and they can censor what people post on their websites. In fact, guess what? Facebook, Twitter, and other social media platforms are not the government. They're actually private entities. They can censor what they choose. On the contrary, they have their own First Amendment right. They are the media, and they get to decide what they can put on, or what they can allow to have on their media platform is up to them. What they will allow to have published and what they won't. Like I said, with our sitting president, underneath misinformation, they wrote, "This has been disputed. This election claim has been disputed." They allowed him to tweet, but they wrote underneath it, "This has been disputed." Now, my question is, there are attorneys that are beginning to argue, and they're filing cases in court that people should be able to express themselves freely and should not be censored off of social media platforms. But the upside of it is much hate speech, misinformation, and obscenity gets censored off of social media sites like Twitter, Instagram, Facebook, and the like. So is it a good or bad thing? You decide. Next amendment we are looking at, we're going to look at the Fourth Amendment. Is there really a right to privacy? And contrary to what you think, there really is no right to privacy. It's inferred from the Fourth Amendment. It all stems from the Fourth Amendment to be free from government intrusion. The Fourth Amendment reads specifically, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." In this case, you can tell Big Brother to butt out. This is actually an opinion of an attorney by the name of Munn, writing for the Yale Law Review back in 2008, that the government monitoring of social media pages, which is very, very easy for them to do, is very, very easy to surveil people over the internet, to know who they are surveilling, who they are looking for, and be able to track somebody over the media would be very easy for them to do. According to Mund, and so far, the government has ruled that the Fourth Amendment would apply, so that information that is acquired through the government surveilling over the internet would be covered by the Fourth Amendment, would not be able to be used in court because of the protections of the Fourth Amendment to be free of government intrusion and an illegal search. So I think that's kind of interesting. And the last amendment I was going to bring up was the Fifth Amendment. And this one came interesting to me because I was reading a little bit about all of the amendments and how they pertain to social media. And this one was somewhat interesting because no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be put in jeopardy of life or limb, nor shall one be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So be careful what you post. Contrary to what is normally would go on in court, self-incrimination or pleading the Fifth Amendment is something that would be protected when someone is on a witness stand would not have to incriminate themselves. But if you put information on a social media post and you confess to the masses over social media, it can be used as evidence against you because you've confessed over social media. And you could not plead the Fifth Amendment because it's a confession that has been made online in public to the masses over social media. So you have to be very, very careful about what you post over the media. And that's pretty much a wrap. There is one more thing I wanted to suggest to you. I do have one more amendment, and it's the Second Amendment. And it's not something that we talk about very often here at UMass Dartmouth, but the Second Amendment is a well-regulated militia being necessary to the security of a free state. The right of people to keep and bear arms shall not be infringed. I actually was working with a Pulitzer Prize winning writer who was working on a book on a homicide case, and I had caught the district attorney in impropriety. And he was writing a book about the defendant, thought that there was reasonable doubt against this particular defendant in court. It turned out that the district attorney it wasn't just impropriety, he's engaged in major wrongdoing. And when I was having this discussion with this particular journalist, he's an author, he told me the only thing protecting the First Amendment was the Second Amendment. And unfortunately, my phone line was tapped. And when I mailed him the information that he needed, the entire conversation was picked up on a phone tap. And on the day that his materials were received when he was on sabbatical teaching at UMass Berkeley, the police went to his house. They claimed an alarm went off and that they found guns that were not registered out in the open in his home, went into his home, seized the weapons, and then charged him in court. So I just thought it was kind of interesting. You might want to think about the Second Amendment as far as does it protect the First Amendment? In this case, this is what this particular author believed, and he ended up kind of getting screwed really badly. He had to get an attorney, and he actually ended up beating the case because he said that he was working with an informant and that he had been picked up on a court tap, and he thought that it was an illegal entry into his home. But I want you to think about it. Is the Second Amendment the only thing backing up the First Amendment? One of the things I found over the summer, something that I had seen for 8 years in Barnesville, is that you can't always trust the well-regulated militia to protect your interests. So I want you to think about that. It's just something I want, just an opinion I want you to think about. And I want you to think. The whole point of this exercise was to provoke thought. So the last slide for you is freedom of expression. It's your turn. I want you to write about anything that meant anything to you in regard to this presentation. Questions that arose, dilemmas created, ideas generated, anything that meant anything to you. And celebrate the life of Supreme Court Justice Felix Frankfurter. He's the pioneer of freedom of expression. He's the founder of the ACLU. He actually was my grandfather's professor. They traveled the country together during the Depression, working for President Roosevelt. And my grandfather will tell you the original intent of the ACLU and where we've gone with free speech is all over the place and not the original intent of Felix Frankfurter. So that's why I've done this particular presentation. I hope that you learned something from it, or at least it provoked thought where you would want to write something about how you feel about anything regarding any of the amendments, how they affect social media, anything you've learned at all. And I would like you to celebrate the life of Felix Frankfurter, who, without his incredible tutelage and tender care, my grandfather's tutelage and tender care, I would not have been able to write this. So thanks, and have a good day. Bye.